Hi everybody, thanks again for being here. I wanted to review a little bit about what we talked last time. We were talking about jurisdiction. We were talking about the in rem and the in personam jurisdiction and how the courts get those two, subject matter and personal jurisdiction, by the summons and a notice to appear, or a short form summons, or by a warrant in a criminal case. But we also want to go back and understand this jurisdiction idea from the perspective we started to talk about in the beginning with the judicial power. See, because that one power of the Constitution that's separate and equal to the other ones, that makes it different, is the judicial power, is that it has jurisdiction over all cases, law, and equity. See, so this is a broader perspective than we look at specifically subject matter or in personam. We're looking at law and equity, and we find that the judicial power is the one Supreme Court has jurisdiction over all cases, law, and equity, and these inferior courts that are created by Congress don't have that jurisdictional power. And this is why when we go to one of their courts and we enter into the proceedings, the jurisdictional power is either from the one Supreme Court or from the inferior court. And we know that we're the Chief Justice of the Supreme Court, so when we walk in there, we bring that power in with us. They don't have it. So then they're going to operate off of our power if we go in and submit. That's why when we go in, we challenge. And then we challenge their jurisdiction to find out if they have the authority to hear both law and equity. Because your statutory laws really come under the equity power jurisdiction that's created by man. The laws of the Constitution are the law of the land, and all the rest of the statutory scheme is the admiralty or equity jurisdiction. So there's no law when we walk into these courts. And then when they proceed without law, then we're proceeding by agreement. So we go outside of the law into the agreement, and then when we agree with them that they have the authority to revenue us, then we have nowhere to go. But if we deny that authority for them to revenue us, then they would have to come with a claim at law, a reason to revenue us, and that would be in a criminal case, would be the criminal in se, the crime in fact, as opposed to a crime that was legislated and said that we have to pay them if we don't do something their way. Okay, so that's when we understand how these courts come together. See, and we know that in the three positions of the Constitution and the three positions that are in the court, each one of those has the two sides, the law and the equity, at the legislative or prosecution table, the law and equity of the judge at the executive power, and the law and equity that comes under the judicial power of the individual that has that jurisdiction over all cases, law, and equity. So now this is the things we want to understand. Once we know that we're the ones with the power, that we are the Chief Justice and we can deal with all these authorities, then we need to dissect the authority and the jurisdiction and find out what a cause of action is defined so that we can get the right to relief. See, so the right to relief is what we're looking for in a court that has jurisdiction. And when we look at these legislative and executive courts, they don't really have the authority to give us the remedy. And we have to understand what a remedy is, what a cause of action is, what authority means, and how the jurisdiction works. Those are the studying up of what we need basic understanding of, those facts. I can touch on them now, but these need to be basically understood so that we can move to the next level, which is the taking action. We have to act on what we know. So I've kind of got it into three categories. We got the first one is that we have to know who we are and gain an understanding of confidence to move the courts. Then we have to know what the procedures and the rules are, which is dealing with the cause of action, the authority, the jurisdiction. And by understanding these things, we can take action and make our objections properly. We put in motions to bring forward the case to expose the fact that these courts don't have authority, and that the opposition or the police officers or any of these executives, they can't give these courts authority for us. We have to agree and volunteer. And when we get that understanding, then we can go in and not volunteer and stop the court and have them go on with their stuff without us involved, because they're legislative or executive and we're judicial. And that's the separate and equal that we have to grasp, that there's three powers and they're equal. And we are just as powerful as the judge or as the attorneys or as the president or anyone else who is simply throwing these words out and using them to control. So we have to understand the words and how they work. Then that also gives us confidence in our position of the Chief Justice, and then we can exercise our powers, law and equity, by taking the action to object or challenge their process and authority. And that's, I think, where they came up with that little sticker that you put on your bumper called Question Authority. And so that's how this all starts, and we get these understandings, and then we can move forward. So you're going to have to study that law dictionary a little bit on some of these words, and then next time I'll go into some of the action and the motions and the way that this is supposed to be set up. So until next time, thanks for listening, and I'll talk to you later.